Norma, if I get a chance, I think my client's in the courtroom, State McLean, trying to get in with a breakout with Jessica Johnson.
Yes, sir.
I guess we could.
Norma, can you go to breakout room 2 with Mr. McLean, please?
Okay. All right, is there anyone who's ready?
I think we're ready on Nicholas Valdez, Judge.
Also, Judge, I've got a 3 o'clock contested CPS setting. I think we're ready on Ms. Martinez as well.
Okay, what is happening with Ms. Martinez? Is that sentencing?
I believe you were to review the PSI, her evaluation for my off, Your Honor, and we were going to proceed to sentencing.
All right, no, I'd already reviewed it. My understanding you didn't have it. Do you have it and have you had a chance to review
Oh,
it?
yes, Your Honor. I got it earlier.
All right, then we will go forward. Who are the parties on Martinez? On Shirley Martinez. It's assault on a public servant. Prosecutor?
Judge, depending on what it is, I can step in. I'm not sure what the.
All right, it's an assault on a public servant. And the state is recommending community supervision.
Okay, it's a plea.
Yes, no, it's sentencing.
Sentencing.
Okay.
All right. Court is going to call 2020 CR 12314, State of Texas versus Shirley Martinez. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Douglas Kapmeyer.
And are you Miss Martinez?
Yes,
Are you
ma'am.
Shirley Martinez?
Yes, ma'am, Judge Boyd.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
All right, the court will note for the record that the defendant entered a plea of guilty on February 23rd, and that plea was taken by video. According to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There's a $1,500 fine to be probated. The state recommends community supervision. There's restitution plus no contact with Ramona Ramirez. Have both parties had a chance to review the PSI report, state?
No, Your Honor, I have not.
All right, state, are you prepared to proceed without reviewing that report?
Judge, could you give me just 1 minute to check with criminal trial?
Yes.
Judge, is it okay if I step in?
Yes.
Okay, Marcus Sanders for the state.
All right, state, have you had a chance to review the PSI report?
Judge, I haven't either, but I am prepared to proceed without reviewing.
All right, defense, have you had a chance to review the PSI report?
Your Honor, I did receive one page. I thought that was the whole report. I'm not sure if that's it or not.
Yes, it was just for a MIC evaluation, MIC mild
Yes.
evaluation.
My client and I went over that. Yes, Your Honor.
All right, are you ready to proceed?
Yes, ma'am.
All right, defense, anything you wish to say on behalf of your client?
I've spoken to the family, Your Honor, and my client, and I do believe she needs help. follow any and all recommendations, but she does want to get that help and then be back with her family as soon as the department feels that that's appropriate, Your Honor.
Ms. Martinez, if I could have you raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Can you tell me how far did you go in school?
I completed my GED.
All right, do you have any children?
I have two that are in the custody of their father.
All right. So will you have a place to stay?
Yes, I have yes, for 32 years. My mother.
All right, and has your mother given permission and said she wants you to be there or no?
Yes, but she doesn't have the money, the fees to get me out.
Okay.
To get a lawyer. Something like that.
All right, are you receiving SSI or anything of that nature?
No, ma'am.
How you support yourself when you're not in custody?
My mom, she takes good care of me.
All right, is there a reason why?
It's a low income base. I do help her with all my siblings. Just follow the commands of our simple Bible, really. I don't know what to say, just keeping those relationships healthy with my 4 siblings and my stepdad.
All right, the siblings that you're helping your mother with, what are their ages?
One's, I'll keep that in mind. One's 34, one's like 44, one's 40, and then the other one's like 50 or something like that.
Why are you helping her with people who are
Not
that
helping
age?
her, but I mean, I just stay in the lines of, there's a lot of anguish, there's a lot of this anger, and I mean, not like that, but I mean, this violent. Now, you want to seek SSI and treatment, you can go to those siblings, but that's not my case. So,
Okay, so this is what I'm trying to figure out, Ms. Martinez. The people that you're helping your mother with, are those people who have mental health issues?
yeah, they have background on that.
All right, is she some type of home health care provider?
Yes, she is. She's a strong one. And now what I say is that because she's one single independent lady. That's all.
All right, and so the people that she is a home health care provider for, are these your brothers and sisters?
No.
So
No.
these are different people.
Yes, ma'am.
All right, do you have any brothers or sisters?
Yes, I do. Those are my brothers and sisters, but we keep it very healthy and just like they have their own lives, everything else. With the links of non-communication, like if I go back to Alcoholics Anonymous, and I don't want to state that, but I mean, when they tell you don't hang up people, places, and things, I refuse to do that. Those are my only relationships I know, and those are the ones I'm going to feed. That's all.
All right, is there anything else from either side?
No.
Nothing from the state.
All right, this is what the court is going to do. The court will sentence you to 8 years in prison, suspended and probated for 5 years, $1,500 fine, probated. There's to be further evaluation with Center for Healthcare Services for DDRF, and that'll be done while in custody.
What does that mean?
They'll let you know. Just give me a moment, okay?
Yes.
There's to be no contact plus restitution to Ramona Ramirez, 150 hours of community service restitution. 40 of those hours will be waived if you provide proof that you've had the COVID vaccination. The court is not requiring you to have the COVID vaccination, but if you do and you provide proof, 40 of your hours will be waived. I want her evaluated for the MIC-MALV caseload, the APSE course. And I do not feel comfortable with your client staying with her mother because there are persons, vulnerable persons in that facility that is her mother's home. And I don't know if anyone's keeping an eye on that home since her mother is taking care of.
I take care of the home. I take care of the home and my stepdad stays in his room.
All right, you're not going to be allowed to stay there because I don't allow people who are on probation out of this court to participate or to help with as home healthcare providers or assistants.
I don't help.
Healthcare providers.
I just have a room there.
All right, that's still a problem because there are vulnerable people in that household and I'm not going to allow that. So they'll be able to find a different place for you to stay. So the defendant is not allowed to reside with her mother as long as her mother is a home health care provider. There's to be no unsupervised contact with minors or vulnerable persons. Proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider with minors. Regular reporting by Zoom or in person. Regular UAs. Field visits. 3 times per month, random. Probation, is there anything else that she needs?
No, ma'am.
All right, Ms. Martinez, is there anything else you need from the court in order to be successful?
Okay, so that means 8 years in prison here or 8 years out there?
Now, you're going to be on probation for 5 years.
Oh,
And if for some reason you're unsuccessful, there's a chance that you could spend 8 years in prison.
oh, okay, all right. Sounds good.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Oh, I signed it, yes.
That was done a month
Did you
ago.
understand it?
Oh, yes. Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you want to know the definition of weapon or ammunition, you need to speak to your attorney. Do you understand?
Okay,
All right, Ms. Martinez, good luck to you. I'm going to send you to breakout room number 2. Probation will be there.
okay.
Judge, will she be evaluated outside of?
No, in custody.
Okay, thank you.
You're welcome.
Thank you, Judge. You want me to go talk to her? Is that,
Yes, I've assigned you to breakout room number 2, and probation will meet you in number 2.
thank you, Your Honor. After that, may I be excused?
Yes.
Thank you.
All right, is there anyone else who is ready?
Judge, this is Alfonso Cabanas.
Cabanas, yes.
Yes, Your Honor, I have Aaron Trevino, family violence. He's in custody. This is just a trial announcement, Judge.
Okay, just one moment. Probation, have you gone to breakout room number 2?
No, ma'am, I'm completing her paperwork right now.
All right, thank you.
And I still think we were ready on the Valdez NTR, Judge, whenever you were.
All right, just one moment. Where is your client, Aaron Trevino?
He's in custody, Judge.
He's in room 4.
Room 4,
All
Your
right,
Honor.
everyone, please do not leave your clients in breakout rooms. Let me see if I can have him come back. Mr. Cabanas, if you can go to breakout room number 4 and have your client come back for me, please.
Yes, Your Honor.
All right, Ernest Acevedo, who is your client?
Nicholas Valdez.
Who's the prosecutor on Nicholas Valdez?
Marcus.
Clerks, do you have the paperwork on Nicholas Valdez?
We're checking, Judge, right now.
All right, and it's just the motion to revoke that you're proceeding on, or is there more?
There's two cases, Judge.
All right, Mr. Valdez, have you been sworn in?
But sorry, Judge, two MTRs, but that's it.
Don't believe I've been sworn in.
Oh, no, if it's just two motions to revoke, you don't need to be sworn in. All right, the court is calling 2020 CR 12335 and 2020 CR 12336, State of Texas versus Nicholas Valdez. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Ernest Acevedo for Mr. Valdez.
And are you Nicholas Valdez?
Yes, Your Honor, I am.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Valdez, did you review a document with your attorney in each of these cause numbers entitled Defendant's Consent to Appear by Video Conference? Did you understand it?
Yes, Your Honor, I did.
And did you electronically sign these documents?
Yes, Your Honor, I did.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily consented to appear by video. And each of the cause numbers, I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am, I did.
Are you the same Nicholas Valdez who was placed on community supervision in cause number 2020 CR 12335 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on June 29, 2021 for a period of 5 years? Is that you?
Yes, ma'am, that's me.
Are you the same Nicholas Valdez who was placed on community supervision in cause number 2020 CR 12336 for the offense of felon in possession of a firearm on June 29, 2021 for a term of 5 years? Is that you?
Yes, Your Honor, that's me.
State, are you proceeding on the same allegation in each motion?
Yes, Judge.
Defense, any objection to the state reading the allegation once and your client's answer being the answer for both motions?
No objections to that, Judge.
All right, state.
From the amended motion, condition number 1, on or about the 12th day of February 2022, in Bexar County, Texas, the defendant, Nicholas Valdez, committed the offense of unlawful carrying of a weapon in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
And condition number 1, on or about the 12th day of February 2022, in Bexar County, Texas, the defendant, Nicholas Valdez, committed the offense of violation of bond protective order in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
We'll waive the others.
Any objections to the state's waivers?
No, Your Honor.
Mr. Valdez, did you understand by pleading true to violation of conditions 1 and 1 in cause number 2020 CR 12335, the court could find it true, grant the motion, and sentence you up to 5 years in prison and up to $1,000 fine? Did you understand?
Yes, Your Honor, I understand.
Knowing that, do you still wish to plead true to violations of conditions 1 and 1?
I do, Your Honor.
In cause number 2020 CR 12335, the court will find violation of conditions 1 and 1 true. And cause number 2020 CR 12336, did you understand by pleading true to violation of conditions 1 and 1, the court could find it true, grant the motion, and sentence you up to 5 years in prison and up to $1,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes, Your Honor.
Court will find 1 and 1 true. Is there an agreement in each of the motions?
There is, Judge, and it's the same for both. We're asking that you deny the motion, alter and amend for SATIF followed by aftercare. Also, we've agreed to TIC the following cases in exchange for his plea of true. First one is County Court 679196. County Court 678-824. Night Mag 649-601. Night Mag, sorry, Grand Jury 766-443. And Grand Jury 765-562.
Is that the agreement, defense?
It is, Your Honor.
Mr. Valdez, are you asking the court to follow that agreement?
That's a SADF agreement.
The agreement that was just stated on the record, are you asking the court to follow that agreement?
Agreement that was just stated. Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, Mr. Valdez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. So what is your drug of choice?
My drug of choice was meth.
Well, I mean, it's not was meth. I mean, that's what's still going on. That's why you're going to SADA.
Correct.
Let me see. And I previously ordered random UAs in the patch. Do you have any children?
Yes, Your Honor. I have 5 children.
And why did you start on parenting classes? Because I ordered that.
No, ma'am, I hadn't. I reached out to my probation officer and got the information that I needed finally, and I was going to start it. Of course, it's too little too late. I understand that. Also, I have Star. She's about to graduate high school at Burbank High School. I have Angel, who's in the Honor Society. She's also straight A student in Burbank High School also. I have Nicholas. He's in middle school, 8th grade, does sports, and I've attended every sports thing that he's had since before getting arrested.
Okay, Mr. Valdez, here's the thing. Your children are doing great in spite of, not because of you. You understand? So you're going to have to do better, and you need to be a parent that your children can look up to. You understand?
Yes, I agree that 100%. I'm ready to make the change and start living instead of just existing. You know, I'm tired of missing out on life with them. You know, I'm looking forward to a chemical-free way of thinking. And thank you.
All right, let me see. All right, probation in each of these cause numbers, this is what the court is going to do. The court will partially follow the agreement. The court is going to deny the motions in each of the cause number, alternate amend conditions to include SATA, followed by aftercare. The defendant is to remain in custody until transferred to SATA. I'm going to want that followed up with felony drug court if they do have room for him. GPS, waive fees, and he's going to have a curfew from 7 a.m. to 7 p.m. Taking consideration County Court cause number 67916, 6788824, night mag number 649601, grand jury number 766443, grand jury number 76552, 7655562. I'm going to want field visits 2 times per month, random once he's released. And all other conditions are to remain. And defense, if you want to see if felony drug court has a position for him, but my understanding, they are on a wait list, so they may not have one for him. But if felony drug court has something for him before SADF, then I'm happy to do that.
I can certainly inquire, Judge.
All right. And the only exception to his curfew probation will be if he's employed and he has to provide proof of that. And Mr. Valdez, with that employment, if it's outside your curfew, the only thing you will be going is going straight to your work and straight back home from your work, no side detours. You understand?
Fully, yes, ma'am.
All right, is there anything else from either side?
No, Your Honor.
All right, we'll close the record. I'm going to send you to a breakout room. Probation will go over conditions with you. I'm going to send you to breakout room number 2. Your attorney can go to 2 with you, or either he can be excused.
Thank you, Your Honor.
You're welcome. Good luck to you. Do better.
I plan on it.
All right, who are the parties on Coleman? Oh, Mr. Valdez, if you look at the bottom where it says the 4 breakout rooms, the 4 little boxes, just click on that. Okay. Who are the parties on Coleman? John Young?
Go with the
Hello,
Ray
ma'am.
Adams, Judge.
Yes.
I'm here on Anthony Salinas on a bond reduction and bond setting request that we made in court last week.
Okay, and did you confer with the state or no?
I did. I conferred with Michael and he was opposed to it. And you ordered us to come back today on an oral motion to reduce and set bond.
That's Anthony Salinas?
Yes, Your Honor.
All right, just give me a moment because he's in a breakout room.
Your Honor, you said something to me before. Sorry. This is Mr. Valdez.
Yes, you need to go to breakout room number 2.
Okay, thank you.
You're welcome. All right, just give me a moment, Mr. Young. Michael's in another room, just 1 second.
Appreciate it, Your Honor.
You're welcome. All right, David McLean.
Good afternoon, Judge. I have Jessica Johnson for an MTR this afternoon. I've got a little bit of a quandary just because my client just informed me that she has conferred with Alan Brown's office and is in the process of hiring him. And so I feel obligated to ask the court to maybe reset this for a week and let's see if we can come back, and hopefully by then she's been able to finalize that. But I think my client should have the opportunity to have the attorney of her choice representing her.
Where is Miss Johnson?
She's in the courtroom, Judge. She's standing in front of the camera. I see her right here.
All right, Miss Johnson, do you have your attorney here with you?
Well, no, ma'am. Technically, I guess he's still my attorney. I was discussing with the other attorney, everything going on with the court, and he said that he's willing to accept the amount of cash that I have and for me to ask for it to be reset, and that I go straight from the courthouse to his office.
All right, we'll see you tomorrow.
Tomorrow?
Yes, so you can leave straight from here and go to his office like you told him you would.
Yes.
So Ms. Ferguson, we're going to come back on Miss Johnson tomorrow at 9 a.m.
Yes, ma'am.
Thank you.
All right, thank you, Mr. McLean.
Yes, Your Honor.
Ms. Johnson, you're going to get a reset form.
And Judge, I'll be present as well.
All right, thank you, Mr. McLean. Have a great rest of your day.
You too, Judge. Thank you. Appreciate it.
You're welcome. All right, is there a prosecutor available to take care of the plea on Mr. Coleman?
I'm here, Judge. I can try to get caught up on it. Is it a family violence or a CTDP?
It's a family violence. I'll walk you through what the agreement is.
Okay.
Thank you. All right, the court is going to call 2021 CR 8217, State of Texas versus Vernon Coleman. Can I have parties announced for the record for the state?
Ryan Gruber for the state of Texas.
For the defense?
Yes, for the defense.
All right, and are you Mr. Coleman? I need you to unmute Mr. Coleman.
Yes, Your Honor, I am.
We're proceeding by video because of the pandemic. Any objection from the state?
None from the state, Your Honor.
Any objection from the defense?
No objection.
Mr. Coleman, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled application for deferred adjudication with community supervision. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor, I did.
I called the cops and all I did was before the cops.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor, I did.
I'm
Yes,
sorry,
Your Honor.
Mr. Adams, did you receive that and review it with your client?
Yes, I did, John.
Court will find that the state is in compliance with discovery. Mr. Coleman, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
That is correct, Your Honor.
That is correct.
Mr. Coleman, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor, I did.
Did you understand you're charged with assault, family second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor, I did, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor, I did, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am, I did.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application? Well, it doesn't appear that there's a request for deferred adjudication. Are you requesting deferred adjudication, Mr. Adams?
I thought we filed an application for both. Yes.
Okay. All right. Yes, I see that. Thank you. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Coleman, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, I did, ma'am.
According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years. There's a $1,500 fine. State opposes your applications for deferred adjudication and community supervision. They will take in consideration CM 95067 and County Court cause number 659794. There is to be no contact with Ashley, ASHLEY, Morris, Morris. And there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am, I do.
Defense, was that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged in indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, off the record for a moment. Can I see defense counsel and state in a breakout room, please? Breakout
Yes, Your Honor.
room number 3. All right, the defendant entered a plea of no contest. State, do you have any evidence to support the defendant's plea?
We do, Judge. State would offer State's Exhibit number 1 and all attachments.
Any objections?
No objections.
Mr. Coleman, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you've applied for deferred adjudication. We will come back on April 25th for sentencing. Is there a need for a TAP evaluation, Mr. Adams?
Go ahead and do it.
Okay. Do you anticipate having any witnesses?
No, Your Honor.
All right.
We may have a witness, but it would probably just be one.
All right. So we're going to come back on April 25th at 9 a.m. I'm going to order a TAP evaluation. Mr. Coleman, if you are released from custody, you'll need to appear in person at the 187 District Court at 9 a.m. on April 25th. Do you understand?
Yes, ma'am. I'm trying to figure out I don't understand what's the TAP. What is that?
The TAP evaluation is basically to see whether or not there are any drug or alcohol issues that you may have. And it's just more information to give to the court.
Okay.
All right. Do you have any other questions?
So I'm not kind of understanding. So I'm come back on the 25th for what reason?
On April 25th, you will come back. I will have received the TAP evaluation and the PSI report. The PSI report is just a pre-sentence investigation report. It will tell me your prior criminal history and other things about you. It will give me a synopsis of the official story of what happened. They will probably ask you some questions as well. Your attorney will speak to you about whether or not you should answer those questions. So it will give me an overview of you. I will make a decision on your application for deferred adjudication or community supervision based upon the report I receive and any other evidence that's presented to me on April 25th. Do you understand?
Yes, ma'am.
All right. So if you are released from custody, you'll need to appear in court on April 25th at 9 a.m. You understand?
Yes, ma'am.
All right. I'm going to send you to a breakout room. Probation will give you more information and let you know what needs to be done.
Okay.
All right. And I'm going to send your attorney to number 1 as well.
All right. Thank you.
Alfonso Cabanas.
Present, Judge.
Mr. Coleman, if you'll just look at the 4 boxes, click on that. Thank you. All right, what is happening with Mr. Trevino?
I just need to announce for trial, Your Honor. I conferred last time with Mr. Villarreal, the assistant prosecutor, but my client's desire is still the same to request a jury trial.
All right. Okay, the court, let me see where we are. He has 3 cases, is that correct?
I believe so, yes, Your Honor.
All right, the court is calling 2021 CR 7554, 2021 CR 7436, and 2021 CR 4722. If I could have defense announced for the record, please.
Alfonso Cabañas for the defendant Aaron Trevino.
And are you Mr. Trevino?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state? I'm sorry, any objection from the defense? I always do that.
No objection from defense, Your Honor.
Mr. Trevino, do you have any objections?
No, ma'am.
All right. Mr. Cabanas, have you received all the discovery in each of these cause numbers?
I believe I have, Your Honor.
Has an offer been tendered that encompasses all the cause numbers?
Yes, Your Honor, there was an offer made back on December 6, 2021.
All right. And Mr. Trevino, are you rejecting that offer?
Yes, ma'am.
Are you requesting a jury trial?
Yes, ma'am.
All right, your jury trial date is going to be April 12th at 9 a.m. If you are not in custody, you need to appear in person in the 187 District Court on April 12th, dressed for jury trial. The courtroom is located at 300 De La Rosa, and it is on the 4th floor. If you are in custody, you will be brought over on April 12th, dressed for trial. You will be brought over wearing whatever civilian clothing you have at the jail. If you wish to appear in a different attire, you need to discuss that with your attorney, Mr. Cabanas. If there are any issues with the clothing exchange, if you will let the court know, we'll see if we can expedite that.
Yes, Your Honor.
Mr. Trevino, your jury trial date is April 12th at 9 a.m. in the 187 District Court. It's located at 300 De La Rosa. When is your court date?
April 12th.
What time?
9 a.m.
Which court?
187.
What's the street address?
300 De La Rosa.
All right, okay. Some people do not get the street address. All right, if for any reason, Mr. Trevino, that there's another suspension of jury trials, then your attorney will be made aware, and in which case you will not be brought over. Do you understand?
Yes, ma'am.
All right, thank you, Mr. Cabanas. Yes?
Ma'am, can I go out to a breakout room again with him?
Yes, and Mr. Cabanas, once you go into a breakout room with your client, I'll need you to make sure that he comes out to the main room.
Yes, Your Honor.
Can you hear me?
Click on the boxes. All right, is there someone here on Vidalis?
Judge, Mr. Featherston is there. He's actually in the courtroom now. He was going over paperwork with Mr. Vidalis.
All right. Let me know when you are ready with the paperwork.
Oh, right here? Yes. Okay. I don't know how close that camera I need to be. Yeah. Right here? Yes. Okay. Your Honor, for police court, we're ready.
Okay, just give me a moment. Michelle or someone from Family Violence, are you able to take this plea?
Sure.
And I'll walk you through the plea bargain agreement. All right, the court is going to call 2021 CR 5893, State of Texas versus Raul Vidalis. Could I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Robert Featherston, Your Honor.
And are you Mr. Vidalis?
Yes, ma'am.
We're proceeding by video because of the pandemic. The court will note for the record that the defendant is present in the courtroom. Off the record for a moment, please. Mr. Coleman, did you meet with probation?
Yes, Judge, we're done.
All right, thank you. All right, we're back on the record. The court will note for the record that the defendant and defense counsel are in the courtroom. Mr. Vidalis, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Thank you. Counsel, I'm going to show you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Vidalis, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears that you're proceeding on the indictment as presented.
Yes, Your Honor.
Mr. Vidalis, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Vidalis, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there should be a $1,000 fine. State recommends deferred adjudication. There should be restitution of $57 to SAPD for drug testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense
That's
is that the
correct,
plea bargain agreement? State is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation and 150 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea.
State offers States Exhibit 1 and its attachments into evidence.
Any objections?
No objections, Your Honor.
Mr. Vidalis, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Have the court will defer finding of guilt. Are you proceeding to sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, if you please the court, we respectfully request that the plea agreement be followed.
All right, Mr. Vidalis, if you're drug tested today, what are the results going to be? And know that I'm asking you this because I'm trying to give you conditions so you'll be successful. So what are the results going to be?
I would be 30 for
right.
marijuana and for methamphetamines.
All right, how often are you using meth?
Every day.
Okay, when did you start using? First start?
Probably about a month before I got arrested.
Okay. How old were you?
28.
Okay. Do you have any children?
Yes, ma'am, I have 4.
What are their ages?
12, 10, 8, and 6.
All right, do they live with you?
Yes, ma'am.
Who else lives with you?
Right now, I resigned with my mother. I moved back in with her so I could be with my kids.
So the person who actually has custody of your children is not you, it's your mother?
Well, she helps me watch them, but I'm the one that takes them to school, picks them up from school, does their homework with them, feeds them. She houses us.
She was?
She houses us.
All right. Is Child Protective Services involved?
Excuse me?
Child Protective Services, are they involved?
No, ma'am.
Where is the mother of the children?
She has her own family.
Has what?
She has her own family. She she got engaged and had a baby and she went on her way.
So what, she's not a part of the children's lives?
Maybe she's seen them in the last 3 years, probably about 6 times.
And you're telling me Child Protective Services is not involved in your life?
No, ma'am.
Has Child Protective Services ever been involved?
No, ma'am.
Are you employed?
I just recently was employed. I do construction.
All right. How far did you go in school?
9th grade. 15 years old when I dropped.
So what are your plans for your future?
Right now it's just to get right.
All right. This is what the court is going to do. $1,000 fine probated, 3 years deferred adjudication, $57 to SAPD for drug testing, 150 hours for community service, restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you take the COVID vaccination with the booster shot, the court will deduct 40 of those hours. There's going to be parenting classes with compadre, e-compadre. You must complete those parenting classes. If you complete those parenting classes, then the court will waive the remaining hours of your community service, but those parenting classes must be completed. CPS compliance, if applicable. There is to be no unsupervised contact with minors. So what that means is you need to make sure that someone else is always in the home when your children are there. Do you understand?
Yes, ma'am.
I'm not going to allow you to have unsupervised contact with them. So there has to be an adult, and that adult has to be approved by probation. Do you understand?
Yes, ma'am.
Proof of employment within 30 days. There has to be no employment as a home health care provider or with minors. I'm going to want random field visits 3 times per month. There's to be regular Zoom reporting. If you can't Zoom, then it'll have to be in person. We're going to do the UA hotline. Do you have a cell phone or a landline, Mr. Vidalis?
I do have a cell phone, but without service. So.
Well, is there a landline?
Yes, ma'am. House phone, yes.
All right, so we're gonna do the UA hotline. Intensive outpatient treatment with probation, but I'm also gonna want a referral to felony drug court. All right, probation, is there anything else that Mr. Vidalis needs?
No, ma'am.
Mr. Vidalis, is there anything else that you need from the court in order to be successful?
No, ma'am.
I'm sorry?
No, ma'am.
All right, and also probation, I'm gonna want a UA. It's too late for him to have one today, but a UA tomorrow, the 10th.
Okay.
By 10 a.m. And let's check for levels so we can see exactly where he is. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Vidalis, you are going to have to try hard to stay drug-free. If there are other issues, probation is here to help you with those issues. If there are past traumas, we can actually get you a therapist to help you work your way through that. You understand?
Yes, ma'am.
But if you continue on the path you're on, what's going to end up happening, you may end up overdosing. Because as I told other people before, the people who are doing these drugs, they're not FDA approved. Anything can happen. I'm going to send you to breakout courtroom. If you can go to breakout room number 1, and probation, if you could meet them in 1 to go over conditions. All right, Ralph Perdigoni, who is the, if I can get someone from the state to stand in.
That's me, Your Honor.
Okay. Michelle, are you able to stand in?
Yes, I can stand in.
Are you able to stand
Yes, I can stand in.
Michelle, you are very popular today. Popular today.
Michelle, I'm back if you want me to step in.
It doesn't matter. I mean, I'm not sure what's going on here, but either way.
I'll do it, Judge.
Okay, awesome. All right, the court is going to call 2020 CR 2099, State of Texas versus Ralph Perdigoni. Can I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Matt Stolhansky.
And are you Mr. Perdigoni?
Yes, Your Honor.
All right, and forgive me, I'm mispronouncing your name each time, so forgive me.
That's all right.
How do you pronounce your last name?
Perdigoni.
Perdigoni. See, it sounds better when you do that with your, if you don't do that with your hands, you can't get it out correctly. All right, we're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Perdigoni, any objections?
No, ma'am.
By video.
No, Your Honor.
And did you review this document with your attorney? Did you understand it? And did you electronically sign defendant's consent to appear by video conference?
Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily consented to appear by video. Showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Mr. Perdigoni, showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you're proceeding on count 1 only. Is that correct?
Yes, Judge.
And are you waiving count 2 in the repeater enhancement allegation?
Yes, Your Honor, that's correct.
Any objections to the state's waivers?
No objection, Your Honor.
Mr. Perdigoni, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you
Yes, ma'am.
understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is theft, 2,500 to 30,000 of a vehicle? That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him? As a factual understanding of the charges against him.
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Perdigoni, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Yes, ma'am. No, ma'am. Rather,
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
no, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am. He's an excellent attorney.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one only. They're asking that your punishment be assessed at 4 years in the prison. There is no application for deferred adjudication. State recommends community supervision. Yes, Mr. Stohansky?
Your Honor, I just realized there's an issue. We're pleading on the state jail to 4 years.
Ah, that is true.
Could
Just
I
one
go talk
second.
to the state right quick?
Just one- Yes,
Apologize.
no problem. It happens. I'm going to send you to breakout room number 1.
Okay.
And everyone, just give me a moment, please. right, so Mr. Stohansky,
Yes, Your Honor.
so are you all proceeding with punishment of 2 years, or what are you doing?
2 years over 4. Yes, ma'am.
All right, I'm gonna let you speak to your client briefly over that, or however long you need. So, Mr. Perdigoni, if you can go to breakout room number 2.
Start video.
I just feel chat.
All right. All right, are we ready to proceed on Mr. Perdigoni?
Yes, Your Honor.
All right, so before we go back on the record, and then we'll put this on the record, my understanding is that your agreement then is for punishment to be assessed at 2 years. Is that correct, State?
Yes, Your Honor, that's correct.
All right. All right, so I'll write that in, and we're going to go back on the record in cause number 2020 CR 2099. Mr. Perdigoni, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand?
Yes, ma'am.
The punishment was to be assessed at 4 years, but that's outside the range of punishment for a state jail felony. So the agreement is for your punishment to be assessed at 2 years minimum. If for any reason the court were to grant your application for probation and if you were revoked, do you understand?
Yes, ma'am.
And knowing that, do you wish to proceed with this plea?
Yes, ma'am.
All right, then according to the plea bargain agreement, the state is proceeding on count 1. Punishment is to be assessed at 2 years in the state jail facility. There's no application for deferred adjudication. State recommends community supervision. They will take in consideration county court cause number 6799381, grand jury numbers 752257 and 752256. Did you understand that to be the plea bargain agreement, Mr. Perdigoni?
Yes, ma'am.
Defense, is that the plea bargaining agreement?
Yes, Your Honor, it is.
And Mr. Stohansky, did you have a chance to confer with your client over the change of punishment to 2 years in the state jail facility?
Yes, ma'am. He was okay with that.
And state, is that the plea bargain agreement?
Yes, Judge, it is.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 120 hours of community service restitution, CATS 1 and 2, and no contact with Sahar, Saher, Maswati, Maswati, WADI. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am. Thing I'm wondering about the community service. Because I'm at stage 4.
We'll talk about it. Just wait.
All right.
All right, did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
All right, then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Yes, Judge. State offer states Exhibit 1 and all attachments.
Any objections?
No objection, Your Honor. And just so you know, y'all's voices are lagging about 6 seconds behind your mouths. So if I'm a little slow, I apologize.
No problem. All right, Mr. Perdigoni, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Yes, Your Honor. First of all, Mr. Perdigoni is currently has cancer. He's had one kidney removed. He has cancer in the other one. He has cancer in both of his lungs. So he doesn't leave the house because of his immunocompromised situation. He is doesn't have much of an income. So we're asking the court to suspend the community supervision, the community service because of that. But other than that, would ask that you follow the plea bargain. And just for the record, I have provided the state with volumes of his medical records.
All right. And is there any restitution with regards to the vehicle?
It was recovered in good shape, I believe.
Judge, we don't have any restitution notated from the victim.
All right, this is what the court will do. Court will sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's 120 hours community service restitution. 40 of those hours will be waived if you provide proof of a COVID vaccination. The court is not requiring you to get the vaccination, but if you do, 40 of those hours will be waived. The remaining community service restitution will be suspended with a doctor's excuse. Taking consideration County Court cause number 679,381, grand jury number 752257, 752256, cats 1 and 2, no contact with Sahar Maswadi, regular Zoom reporting. If for any reason you can't report by Zoom, then it needs to be in person, regular UAs, or the patch. And if there's an issue with UAs, again, he will need to have a doctor's excuse for that.
Yes, ma'am.
All right, probation, is there anything else that Mr. Perdigoni needs?
No, ma'am.
All right, Mr. Perdigoni, is there anything else you need from the court in order to be successful?
No, ma'am, thank you.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, if there's nothing else, we'll go off the record. Good luck to you, Mr. Perdigoni. I'm going to send you to a breakout room with probation, and probation will go over conditions with you, and you can be excused from that room.
Thank you, Your Honor. Have a good day.
Thank you. You too. I'll send you to breakout room number 1.
May I dismiss, Your Honor?
Yes.
Ma'am.
And Mr. Perdigoni, if you'll look in your box, you can go to number 1.
All right, thank you.
You're welcome. All right, John Young and Bobby Yibia.
Yes, Your Honor, I'm here.
Yes.
Robert Gebbia here.
Okay. All right, Mr. Gibbia, what is happening with your case?
Good afternoon, Judge. I'm here for Mcdalia Salazar. And Ms. Salazar and I still have some discovery that we need to complete with the district attorney's office. We did execute today a protective order for the release of CPS records that should be filed and good to go. We'll go over that. The state still has to review the file to make a competent plea bargain offer. So we would like to come back for a discovery compliance hearing.
All right, Ms. Ferguson, can I have a 30-day reset on Ms. Salazar, please? And the court has approved that order for the CPS records.
Thank you, Your Honor. I appreciate that.
All right, we're going to come back on April 11th.
Sounds good, Judge. April 11th. I hope you all have a wonderful afternoon.
Thank you, you too. And Ms. Salazar, you're excused.
Thank you.
All right, and John Young, who is your person?
Anthony Salinas, Your Honor.
All right, and what is happening with Anthony Salinas?
We came in a day or two ago, made an oral request for bonds to be set and a bond reduction. I discussed it with Michael Villarreal. He declined to agree with me. And you set it for a hearing today, and he said he was going to go forward with the police report, and I have one witness.
All right, just give us a moment. I just have a notation in my chat box that they are upstairs with some sort of meeting, so just give me a moment. So everyone, I know it's been a long day for everyone, but just put some patience in your pocket. It's going to just be great. And Ms. Ferguson, I'm going to put a couple of things in the chat box to you, please.
Yes, ma'am. All right, Xavier Garcia.
Yes, ma'am.
All right, and Solomon on Xavier Garcia. This is a compliance hearing. Do you have the report on that?
Yes, ma'am. Let me send it to you right now.
Thank you. And is there a Jesus Guitron here?
Judge, I thought that was taken care of earlier. Isn't that with Martin Guerra?
Let me see. What page is that on?
He's on the recall.
Just one moment. Let me see if it's still. You are correct. That was taken care of. And just give me a moment, Mr. Garcia.
I just sent it, Judge.
All right, thank you. All right, Mr. Garcia,
Yes, ma'am.
you know why you're here and what your issues are?
Yes, ma'am.
All right, so what are you doing to make sure we don't have those issues?
I mean, honestly, I got the drug patch. I was doing the UAs and I had no problem, but when it comes to the drug patch, the type of work I do, like I always go and they always tell me they can't accept it because
No, I have a positive for cocaine in December.
Yeah, but my PO just told me about it like literally last month. I'm like, oh, man, I don't know. He tell me everything too late. I mean,
well, I mean, here's the thing: you can't be using drugs while you're on probation.
yeah.
So, I mean, whether he told you yesterday or today, I have a positive for cocaine. So, on your case, do you want to be locked up?
Oh, ma'am.
All right, then you've got to do things so that that does not happen, because that's what those are the options you're giving me, right?
Yes, ma'am.
So, I mean, if you want to continue on the path that you're going on, then what's going to end up happening? You can go to the Bexar County Jail. You can go to the Bexar County Jail for up to 180 days, or you can stop using drugs and do what you need to do in order to be in the free world. So the options are yours. So what do you want to do?
I mean, I got a job, so I mean, I want to stay out here, but I mean, I can't do a weekly UA.
You can't stay out there and use drugs.
Yeah, I understand that.
I mean, that's not it's either yes or no.
Yes.
So you're at the point where either you want to do drugs or either you want to be on probation in the free world. And I don't know any drug that's worth going to jail for and potentially 180 days. And then not only do I have that, I have high readings on probation. That's not good either.
High readings, like, what is that?
Oh, that means that when you blow and when you're tested for alcohol, that it's high. It shouldn't be that high. That's what that means. That means that you're drinking alcohol. Do you understand?
Yes, ma'am.
So now you got to ask yourself, is alcohol worth it? I mean, some people may think alcohol is worth going to jail for. I don't know. I haven't been in a situation where I thought alcohol was worth me going to jail over. So do you think that's worth you going to jail for 180 days?
No, ma'am.
So you're going to have to do better. So you're going to do AA meetings. You're going to do 90 meetings in 90 days. That's what you're doing. You understand?
Yes. What is that? What I don't understand. I don't. 90 meetings, 90 days, just every day.
Yes. Yes.
Okay.
And if that doesn't work, then the next step is going to be a motion to revoke. It's going to be filed against you. Do you understand?
Yes, ma'am.
All right. I'm going to send you to breakout room number 1. And Ms. Solomon, can you make a notation if there's another high BRAC reading, then a motion to revoke is to be filed?
Yes, ma'am.
All right. I'm going to send you to breakout room number 1. Bob Behrens?
Yes, Judge.
Yes, what is
Sorry, I
happening with
got
your
knocked
client?
off the meeting. Sorry about that.
No problem. So what are we doing with your
So I had sent a chat to Michelle about talking, and we were going to try to get to a break room, but she was in the middle of the plea. So
All right.
Judge, I'm happy to go confer. I put him in room 11. I can send us back there.
All right. If you'll go to room 11, she'll meet you there.
all right, no problem.
All right. So Mr. Featherston and Mr. Potts, just give me a moment for the state to zoom back in.
Sounds good, Judge. Thanks.
All right. Thank you. Thank you for your patience.
Of course.
Brenna, he says that like everybody has patience.
Judge, is it family or CTD that you need?
It's family.
Okay.
Judge, I don't mind spending all day here with the wonderful staff of the 187th.
Oh, see, Brenna, you know how you said the wonderful staff, but he didn't mention the judge.
That's because, Judge, I think you're more than wonderful. That's why.
It's because we're wonderful because of you.
Judge, we have the patience of Job.
Oh, hey, Job had some patience. You know, until you really read that story, it's like Job had a lot of patience. But I think Joseph had a lot of patience too. And a lot of forgiveness against his brothers. And also, Miss Ferguson, we need Sean Hendrickson. And so everyone, just give me a moment.
Michael, you're back. You're muted.
I'm sorry.
Norma, well, I'm gonna need to get in a breakout room with Mr. Paredes, or I can just call him when we're done, but I need to let the judge know what's going on.
All right, what is happening?
Oh, hi, Judge. So there's a cross complaint on file with the complainant in Mr. Paredes's case as a arrested person, a defendant, and a case against him, also for assault. There are some issues with the complainant and some mental health things going on, and Michelle would like me to provide her some information about that. So I was going to ask Mr. Paredes to send me an email, because he and I have discussed it, but it's not in writing. And then she would like me to forward that to her so she can consider whether she really wants to pursue this case.
All right, so I see where I recalled it before for the same issue. So this is going to be the last time that this is going to be recalled for that. So state, how much time do you need?
Judge, this is information defense was going to provide, so they may be in a better position to say, but I wouldn't think it would be more than a couple weeks.
Yeah, I would think that would be fine, Judge.
All right, so Ms. Ferguson on Gabriel Paredes, can I have a 3-week reset, please?
And Gabriel, I'm gonna call you after we're done, okay?
All right, so we're going to come back on April 4th.
April 4th.
Yes.
All right. And are we excused for now?
Yes.
All right. Go ahead and leave the meeting, Gabriel, and I'll call you.
All right, so then we're going to take up Mr. Young. We're going to take up this matter with Mr. Featherston, then I'll take you up next because they've been waiting longer than you have.
I find that hard to believe.
You find it hard to believe?
I'm gonna go make a pit stop. Don't do anything until I get back.
Okay. John is always nice.
This court is ADA compliant.
Okay, and let me see. All right, so we are going to go back on the record on Tristan. And the defense has filed an amended motion for continuance. So we're back on the record in 2019 CR 8838, State of Texas versus Nathaniel Tristan. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Robert Featherston and Adam Paul's, Your Honor.
And are you Nathaniel Tristan?
I am, Your Honor.
All right. So the defense had filed a motion for continuance, which the court denied after hearing argument. And the defense has now filed amended motion for continuance. State, have you had a chance to review the defense's motion for amended motion for continuance?
Yes, Your Honor.
Okay. And are you prepared to proceed on that?
Yes, Your Honor.
All right. All right. Defense, it's your motion.
Yes, Your Honor. If it pleases the court, we'd like the state to proceed.
Okay, but you've added Dr. John Fabian in your motion?
Yes, Judge, we have. We've also indicated that his presence is material for our case in both guilt, innocence, and in punishment.
Just one moment. All right, so the jury trial in this case, defense would be scheduled on March 21st. So are you saying that your expert is not available on March 21st that week?
Judge, the short answer is yes, Your Honor. The long answer is we got a hold of his secretary after our appearance this morning. We asked for her to send his trial schedule, which is in the motion, and what availability dates he currently has. Judge, he's suffering the same problems that everybody else is suffering from. 2 years of really no trials, and now everyone is trying to pull all the experts in all different directions. And so we currently, that's what he has open on his schedule. We'd like to get something nailed down pretty quick because that might change tomorrow.
All right. State.
And Your Honor, I would just like the court to take judicial notice that there's been 2 motions for continuance previously filed by the defense. The first one being on January 28th of 2020. And in that motion, an investigator was unavailable and the case was continued. And the second motion for continuance was filed as recently as December 16th of 2021. In that motion, the defense also alleges in this time that their expert, presumably the same person, has been designated by them as their expert for this case for purposes notice to the state, has been unavailable. And so we're seeing a pattern of unavailability by this particular witness. I would also note that the current motion that's set before you is not compliant with Article 2907 of the Code of Criminal Procedure as it relates to subsequent motions for continuance by the defense. It doesn't list out the materiality, specifically what about his testimony and what his anticipated testimony would be, as well as a number of 8 other things that are about missing on this motion. What concerns me most, Judge, is that on this newest motion, in the next 5 or 6 months, we have 7 days that he's available. And so are we just going to be, in this continued pattern of it? I mean, because part of this motion is for a proper motion for continuance under Article 2907 is that there's a reasonable expectation of proceeding the same at the next term of the court. And so are we going to be dealing with somebody, if we set this June 2nd, who's all of a sudden going to have some unavailability issues? And so number one, I think the motion should be denied because it's non-compliant. And number two, I think this is a third motion for continuance. This clearly lies with the discretion of the court, and we're asking that we proceed to trial. I'm sure that if Mr. Featherston subpoenaed him, and he's currently not under subpoena, the defense expert in this case, that he would have a greater, how shall I put it, incentive to show up to trial. And so we're asking that the court deny the motion.
All right, defense.
Judge, if the court will check the docket sheet, quite frankly, it's been so long, I can't remember if the court actually ruled on those 2 prior filed motions, both during COVID. And with respect to materiality, Judge, at this time, we do not want to disclose our trial strategy to the state.
All right, so this is where the court is at the moment. There's a witness that the defense wants, which is this Dr. Fabian. And there's a witness that the state says is only available for certain periods of time. Is that correct, state?
That is, Judge. I mean, that's for our argument. I mean, we want to proceed because that's our reason, but there's other legal reasons that this case should proceed.
Okay, and state, when is your witness not available?
Let me double check the dates, Your Honor. I'm sorry.
Oh, no problem.
I don't want to say the beginning date of when it is. I just know that she's going to be available specifically for this. I got to check with Marina real quick. But I know that she won't be back until, she's not expected to be back until early July. But I know that she's available for this date, and I don't want to mislead the court as far as the date.
All right, everyone, just give me a moment, please.
And Judge, if you can hear me, it's the 27th.
All right, can I see the state and defense in breakout room, please? And breakout room number 1.
Yes, Your Honor.
And Ms. Ferguson, can you meet me in breakout room number 1, please? All right, we're going to go back on the record. In 2019 CR 8838, the court had an opportunity to have a discussion with the state and the defense and also the court coordinator in the breakout room. This motion for continuance will be granted. This case is being set for jury trial for July 19, 2022. Defense, any objections to July 19th as a jury trial date?
No, Your Honor.
Mr. Tristan, any objections to July 19th as a jury trial date?
No objection, Your Honor.
And defense, have you received all the discovery?
That we're aware of, yes, Your Honor. We certainly have everything for Bear Pig.
Was an offer tendered?
Yes, Your Honor.
And Mr. Tristan, are you rejecting that offer?
I am, Your Honor.
All right, Mr. Tristan, your plea deadline date has expired. The court will not consider any plea bargain agreements after today. If you decide to enter a plea, it'll have to be open to the court. Do you understand?
I understand, Your Honor.
All right, then our jury trial will be on July 19th. That will be at 9 a.m. Mr. Tristan, you'll need to appear dressed for trial in court on the 19th of July at 9 a.m. The courtroom is located at 300 De La Rosa. It's on the 4th floor. Do you understand?
I do, Your Honor.
When is your jury trial date?
It's going to be on July 19th
All right, what time
at 9 a.m.
and which court?
187.
All right, we will see you then.
And Judge, if I could, I'm sorry to interrupt. Another portion of today's matter was supposed to be pretrial motions. I don't mind keeping Mr. Young waiting a little bit longer if you want to handle those right now, or if you just want to give us a date in the future.
Just give me a moment with that.
Thank you, Judge.
To the clerks, could I have the pretrial motions on Mr. Tristan? I don't have any motions.
There's 11, Your Honor.
Real quick, Judge, because it's quite a bit of them, so I don't know which ones they're talking about.
There are 11?
Yeah, there's 11 of them.
Okay, all right. So what we're gonna do then is we're gonna set this on a different date. Ms. Ferguson, when can we set that? Okay, we're gonna come back for motions on March 21st at 2 p.m. And defense, if you can make sure you filed all those motions. I don't have copies of them. To the clerks, could you make sure I have copies of the motions on Nathaniel Tristan?
Yes, Judge.
Your Honor, may I address the court?
Yes.
Judge, I have a setting in Comal County for a continuous sexual assault case. And quite frankly, I don't know if it's going to go or not, but it's scheduled for the 21st.
All right, Ms. Ferguson, let's see if we can do it before then. You know, there keeps being a little buzzing sound up here. Is that the
I think it's someone's smoke detector.
Yeah, I hope that's not mine. Is there anyone there who needs to change the battery in their smoke detector?
I don't even think we have.
I think we have those at the office, Judge.
Oh, we're just on our own. It is a government building, so we don't have smoke detectors. All right, March 14th at 2 p.m. And that's when we'll have motions. All right, you all are excused.
Thank
And
you,
to
Your Honor.
the-
Thank you, Judge.
You're welcome. And to the clerks, could I see you for a moment, please?
Thank you, Judge.
You're welcome. Brenda, it sounds like it's right here in my office, though.
I'll
It's
be right
not.
there with batteries, Judge.
I think it was Mr. Tristan's.
Yeah, I do.
Ah,
It didn't
okay.
happen until you unmuted.
Ah, okay. One second. Mr. Featherston,
Yes, Your Honor.
I'm going to send you to breakout room number 2. The clerk is going to meet you there, so he'll know which files you all are going on.
Yes, Your Honor.
Well, which motions you're going on, so that they'll be able to print out the ones that are needed.
Be glad to chat with him, Judge.
All right, thank you. All right, patiently waiting, Mr. John Young.
It is I.
Yes, who do you have?
I have Anthony Salinas.
All right, you have been so patient. I appreciate that. So what is happening with Mr. Salinas? We're doing the motion for a bond reduction, correct?
Yes, I made an oral motion. You said that would be okay. Michael was there. He and I had conferred. He had not agreed with me. And you told us to come back and argue about it.
Yes, and I have it written right here. If only I would read that file. All right.
Judge, I'm standing in for Michael.
I tell you what I'm requesting on each one.
Okay, all right, awesome.
Sorry, Judge, I run to a witness meeting. I left
Okay.
to do this. I'm sorry. I'll be back though after, I promise. Sorry.
No, bye-bye. Have a good one.
And Judge, I may have some exhibits. Mr. Young, could you give me your email address? Do you have access there?
Yeah, if you want, she can send it to the deputy, Mr. Young. And then you can see it and discuss it with your client if you wish to. Hey, this is the patience of Job, right?
2 hours ago, I would have.
But you know what? You have to be patient with your magnolia tree too. We don't know what's going to happen.
This wouldn't have been done to me if I had magnolia blossoms in my hand. May I tell you what I'm asking for on each of the 2 cases?
Yes.
Okay. We have a violation of protective order, 2 priors, 2020 CR 5977.
Mm-hmm.
He is currently remanded without bond on that. I'm asking the court to amend that and place a $10,000 bond on that charge. If there's any GPS requirements attached to it, I ask the court to waive the fee, and I ask it to be at least partial so that he's allowed to work. He has a small business refinishing concrete. It was a family business that his father died, and it's his business now.
Okay.
And then the second one has a $40,000 bond on it. It is charged as a burglary of habitation with intent to commit an assault, 2021 CR 10247. I would ask the court to amend the $40,000 bond to be a $20,000 bond with the same requests on GPS if it is imposed.
Okay.
And now I would be happy to go over the prosecution's evidence.
All right, we will do that. And they're emailing it. And so I'll send you to a breakout room with your client and you both can look at what evidence they want to submit.
And Judge, what is the email address for the court?
It's Deputy Laura. It'll be her email.
Okay.
And she's listed in the as Norma Laura.
Michelle, can I ask, is this anything other than the police reports that have already been provided on e-discovery?
Well, I was gonna submit the indictments for the priors. I mean, they've got the name of the same victim in these cases. I mean, I don't know if that's,
And I just sent you her email address in the chat box in case you didn't have it.
okay. And John, you had a witness you were gonna call, right?
I do.
Do you mind saying who your witness is?
We have one, Amy Sanchez.
Okay. Okay, I just sent it.
Okay. And Mr. Salinas, I'm going to send you to breakout room number 1 so that your attorney can show you the state's exhibits that they're looking to submit.
Judge, I actually have 2 more. I'm going to send them right now, and then I'll pop in the breakout room to let them know.
Okay, and I have to go. All right, John Young, you are ready to proceed?
Rip snorting and ready to go, Your Honor.
All right, awesome. The court is calling 2021 CR 10247 and 2020 CR 5977, State of Texas versus Anthony Salinas. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the
John Young
defense?
for the defense.
And are you Mr. Salinas?
Anthony Salinas, yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objections to us proceeding by video? State?
No, Your Honor.
Defense?
No, Your Honor.
Mr. Salinas?
No.
All right, we are here on a motion, an oral motion. The defense is requesting a bond reduction and also that a bond be set in 2020 CR 5977. This was actually scheduled yesterday, but I told the defense counsel to come back today. And state, are you ready to proceed?
Yes, Your Honor.
All right, and defense, are you ready to proceed?
Yes, Your Honor.
All right, defense, it's your motion. Do you have any witnesses or evidence to present?
I do. I have Amy Sanchez, Your Honor.
All right, Ms. Sanchez, if you can come up, please. Ms. Sanchez, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you could state your name for the record, please.
Amy Sanchez.
All right, defense.
Thank you, Your Honor. Ms. Sanchez, how do you know Anthony Salinas?
I've known Anthony for over 35 years.
Okay. Are you in a relationship with him?
No.
And at one point on a violation report, they indicated that they had come to your house where he lived. Is that true?
He was living with me. Yes, he was living in our bathroom.
Okay.
I gave him a place to stay.
Okay, so you just allowed him to live there?
Yes.
But you and he didn't have a relationship?
No.
All right.
No.
Did he work for you at that time?
Actually, I was helping him to get his business back going, get it back up and running. That's what I was helping him with. So I was helping him.
And what was his business?
He resurfaced his countertops and bathtubs.
Okay. And was that formerly his father's business?
It was something that he started when his father was alive.
All right.
And his father was as well helping him to get back on his feet and start the business back up again before he passed.
When did his father die?
The 14th of August, I believe.
All right. And Your Honor, if you look at the documents that the state has submitted, one of those is a violation report from the 14th of August. And what happened on that day when his father died?
Well, they notified Anthony by phone, and Anthony just was really upset and wanted to get to where his dad was going and cut off the monitor, and he left to work and he was headed over to his dad.
All right. And there was a second violation report from October 15th. And on that, then that's in 2021. And there's a woman, Denise Valdez, I believe, that was listed as the complainant in these charges and in previous charges, correct?
Correct.
And he was accused of going to an address where she was living while he was on a GPS monitor. Were you familiar with that?
Yes, I was.
Now, you know who else lived at that address?
And I believe she didn't live there though. It was one of her family members, and he went to do their tub, and then she gave that address after she had moved to give them but she wasn't living there.
Okay.
I'm sorry, what did she say? She went there to do what?
To redo a tub, because that's what he does. He resurfaces countertops and tubs. And that's where Anthony was at, resurfacing a tub. And then Denise called in to make the report that he was at her house, but she didn't live there.
And if you look, Your Honor, at the violation report of 15 October of 2021, you will see that pretrial services says that that address was not listed on their database. And in fact, the defendant hadn't been told that Denise was going to be there. But after the fact, they were notified that he had been there and that she had been there. And that's why they issued the violation report, even though he had no knowledge that he was in violation at that time. Now, does Anthony have a business going right now?
Yes, it's called two-tone resurfacing.
And does he have a number of contracts outstanding that he needs to work on?
Yes, well, that's what he was doing prior to his dad's dying. He was getting the contracts going. He had landed a couple of apartments and he was working with Lackland Homes.
And can you tell us, would you be able to bond him out with his family and friends on a $40,000 bond that is set right now on one of these charges?
No, not on the 40,000. That'd be a bit much.
If the judge is able to set this bond at the $10,000 I requested on the violation of protective order and reduce the burglary charge bond down to 20,000, do you think you might be able to get some help and get that done?
Yes, that's what we need, just to get him out so he can go back to work so that he can take care of all these outstanding bills that Anthony has.
Now, would it be an extra burden to try and pay the $300 a month GPS fee if the judge imposes a GPS requirement?
Yes, it would.
If the judge waives that fee, would make it possible to get him out?
Yes, most definitely. Most definitely.
All right. No further questions, Your Honor.
All right, State.
Good afternoon, Ms. Sanchez.
Good afternoon.
Okay, you said on August 14th, 2021, defendant cut his monitor because his father had passed away, right?
Right.
Are you aware that someone else, based on the report that you and defense looked at, said that the defendant had left to go to Sonic and would be right back?
Anthony was residing with me and he was working. No, I was not aware because he was working. He stayed, his address, if you see on his monitor, it was at 110 Flan Alley. That is my address.
At any rate, he cut off his monitor.
Right after he got the news that his father died, yes.
And are you aware that that same date, August 14th, 2021, is the offense date alleged on his burglary habitation case that we have pending, 2021 CR 10247, that same date he cut his monitor is the day that he's alleged to have committed that offense? Okay. And you know that Denise Valdez, are you aware who the victim is in that case?
Yes, ma'am.
And what is that victim's name?
Denise Valdez.
Okay. And are you aware who the victim is in the 2020 CR 5977 violation bond protective order 2 or more prior case?
Yes.
And who is that victim?
Denise. Like
Okay.
I said, I've known Anthony.
Are you aware that the defendant has previously been to prison twice before?
Yes, I am.
And in cause number 2008 CR 7919, the aggravated assault with a deadly weapon where he was sentenced to 8 years in prison. Are you aware who the victim is on that case?
No, I'm not. I think it's Denise, but I'm not sure.
You think it's Denise though? Okay. And then on 2014 CR 5692, assault family second, where he was sentenced to 2 years in prison. Were you aware that Denise Valdez was the victim on that case?
No.
Are you aware that he's got other misdemeanor convictions against Denise Valdez as well?
No.
Are you aware of that? Okay. I'll pass the witness.
No further questions, Your Honor. No further witnesses.
Any other witnesses, defense,
No,
or
Your
any
Honor.
other evidence?
No.
All right, state, any witnesses or evidence?
Judge will offer the exhibits that were previously sent. States Exhibit 1, which is the 2008 CR 7919 indictment. States
Any
Exhibit-
objection, just one second,
Sorry.
any objection to state's exhibit number 1?
No, Your Honor.
All right, that'll be admitted for purposes of this hearing.
States Exhibit 2, the 2014 CR 5692 indictment.
Any objection for this hearing?
No, Your Honor.
That will be admitted.
States Exhibit 3, the burglary habitation report from cause number 2021 CR 10247.
Any objections for this hearing?
No, Your Honor.
All right, that will be admitted.
States Exhibit 4, the violation report or the violation of protective order report for cause number 2020 CR 5977.
Any objection for purposes of this hearing?
No, Your Honor.
All right, that will be admitted.
States Exhibit 5, the pretrial bond violation reports for cause number 2020 CR 5977.
Any objection for this hearing?
No, Your Honor.
All right, that will be admitted.
And States Exhibit 6, defendant's Bexar County criminal history.
Any objections for purposes of this hearing?
No, Your Honor.
All right, that will be admitted. And for the record, states exhibits 1 through 6 is admitted into evidence. State any other evidence or witnesses?
Just argument, Your Honor.
All right, then defense, it's your motion. I'll allow you to proceed first.
Thank you, Your Honor. Mr. Salinas, as we've said, is a small business owner. In order to keep it alive, he has to be out there working. The violation reports that we've seen indicate that there were extenuating circumstances on each of these incidents. The previous charges is somewhat lengthy, criminal history. Those are all facts. We can't get around that, Your Honor. It's there. But in this instance, we believe that he should be allowed bond on his violation of protective order case. We believe that a $10,000 bond would be reasonable. We do ask that the $40,000 bond on the burglary of habitation charge also be reduced to $20,000. And if you do impose any GPS requirement, we ask that it be partial GPS so he can work, and also that the fees be waived. Nothing further, Your Honor.
All right, state.
Judge, we ask that you continue to keep the defendant remanded on the one case and that you not reduce the bond from $40,000 on the other case. Due to the defendant's criminal history and the facts and circumstances of these offenses as alleged in the report and the future safety of the victim, this defendant, we'd ask that you take judicial notice or refer to the indictments in this case. In both of these cases, the violation bond protective order 2 priors and the burglary habitation, the victim is the same, Denise Valdez. We sent you the 2 prior indictments for which the defendant has been convicted and which are alleged as the habitual offender enhancements. It's been a long day. And the new indictments, it's that same victim, Denise Valdez. And he also has several other convictions, if you refer to his criminal history, for violence against a family member and violation of bond or protective order. He does not comply with his conditions of bond, as is evidenced by the violations reports, his violation of the no contact order, the GPS strap tampering. There is no way that the court can ensure that he will not continue to pose a threat to the victim in this case. And because of that, we ask that you deny the defense's motion.
All right, defense, it's your motion, so I'll allow you the final argument.
I was wondering if you're going to do that.
It's rare
Yes,
that
Your Honor.
defense counsel gets the final argument.
Yes, Your Honor. And in this instance, the things I've already said are the same things I would say now. We believe that his history is there. Yes, it's a long criminal history. In this instance, we need to see if we can get him a bond so he can at least continue his life and continue to be a productive member of society.
Okay. All right, after considering arguments from both sides and the evidence that's been submitted, defense counsel's motions will be denied. We're scheduled for a jury trial in Mr. Salinas's case, the violation of bond. What I'm going to do is I will give you all a plea deadline date because I know there's the burglary of the habitation, which hasn't had as many settings as the violation of bond or protective order. Mr. Young, on the burglary of the habitation, have you received all the evidence in that case?
And I'm not sure right off the top of my head, Your Honor.
All right, so what I'm going to do is I'm going to recall these cases for 3 weeks, and it'll just be Mr. Young's to make sure that you have all the discovery and to make sure that you receive an offer from the state that encompasses both cases. And then after that date, I'll give you a plea deadline date. Ms. Ferguson, can I have a 3-week reset on Anthony Salinas, please? All right, we're going to come back on April 6th in state. If you could make sure, I don't know if you have or not, but if you can make sure that you that Mr. Young has received all the evidence and that you are ready to make an offer on that date that encompasses both cases.
Okay, we will, Your Honor.
Thank
All
you,
right.
Your Honor.
Do you need to, Mr. Young, do you need to speak with Mr. Salinas?
No, I'll go over and see him this weekend, Your Honor.
All right, thank you so much. And thank you for your patience, Mr. Young.
Thank you, Your Honor.
All right, thank you, Mr. Salinas. Norma, 14A,
Thank you.
can go back.
Thank you, John. Amy.
You're welcome. All right, so everyone, I am going to stop the live stream.